Thank you very much. And Judge Plavšič said everything about my topic as well. So I can say that thank you very much, and I can leave the floor. No, I will. I will focus on restitution cases because also that problem was tackled. But the problem is very complex. So I would start with the issue of nationalization, going back in history. And first of all, I have a radical opinion on this issue. There is no such legal institution as nationalization. Why? Why? I can explain that, of course. Nationalization is considered as was considered as a revolutionary act of taking private property, but in reality, this nationalization is nothing else than expropriation. And what is the consequence? This is an expropriation infected by ideology, and an illegal expropriation because the conditions which were set even in the 19th century constitutions were not met. Compensation, just compensation, and previous compensation, so that was not met. So we can create an ideological blur around the notion of nationalization, but in itself, that what happened at that moment was illegal expropriation. Nationalization in itself excluded compensation. But you can find in some of the nationalization laws, you can find referrals on future compensation. There was no compensation. Why? Because if the totalitarian state would given compensation, that would mean that the exploiting class of the bourgeoisie is preserved. We take the property, we give compensation. So that exploiting class is not annihilated. So compensation was never intention, even if we can find some promises of future compensation in the nationalization legislation of that period. Coming to the issue of the European Court of Human Rights and Restitution Cases, this is a complex relationship, and the court faced hundreds of cases. And the first issue is that the court, how can deal with those cases? And the court said several times, no, it's not my problem. Let's take these issues. First question that is the ratione temporis issue. For example, there is a moment of ratification of the European Convention on Human Rights. For example, in case of Hungary, 30 years ago. So we have this event dedicated not only to the seventh year of the convention, but also 30 years of ratification. What happened before ratification? The court said that you cannot deal with that problem because for example, I can take a Romanian case, Costandache versus Romania, in which stated that the nationalization took place in 1950. So what we can do if Romania ratified the convention in 1994? So we cannot apply the convention to those cases. So the court said no, based on the issue of ratione temporis application of the convention. But the applicants were clever, and they said that let's raise an issue. If the state took our property, this led to a permanent confiscation of and a permanent deprivation, which is still continuing in this moment. So, dear court of European Court of Human Rights, please apply the convention because my right is affected even in this moment. So this is a continuous deprivation. And the court said against no. Mainly the court said that deprivation of property is an instant act that happened in 1949 or 1950 or 1948, that happened at that moment, and that right of property ceased to exist. We can discuss if this approach is correct from the point of view of Roman law, for example. Of course not. But if I were there as a judge, I would probably have the same cautious approach. But as a professor, I can give my sense of justice a freer rein. And my problem is that this continuity argument is not so simple as the court said, this no approach. Because there are different types of nationalization. For example, there is nationalization which was realized in respect of the legislation in that moment, the totalitarian legislation. We can say that, okay, that was not in a breach of that legislation. So that was an instant act. But how we can deal with those cases when even the totalitarian legislation was breached and the conditions set by the law for nationalization were not met? Or the nationalization took place only in fact without any legal basis, because we have such cases. There is no continuous deprivation. The court said there is no such continuous deprivation. And as I said, I can understand the point of the view of the court, because the court certainly did not want it to look back to that past, because it would not found anything beautiful, just lawlessness and the mockery of law by the totalitarian state. But honestly, and this is one of the main points which I want to make, we cannot put on the European Court of Human Rights the burden facing up the past, which the individual states from where we came, actually we can say that have not been able to fully cope with. So if state policy on restitution is in some point of view of failure, we cannot blame for that the European Court on Human Rights. Again, the no question. The court said no also on the issue that if the convention gave rise to an obligation to restitute property. Because the court was asked that the post-totalitarian states must restitute property or not. And the court was, again, very cautious and did not want it to intervene in the sphere of sovereignty of the different states. And because of fear of the consequences, we can take an example, a country which is not represented here. For example, a case against Albania can have huge economic effects in any of the countries of the region. So the court said, even in this case, no, it's not my problem. The convention did not give rise to such obligation to restitute property, and practically, in several cases, the court said that each and every state is actually free to determine its policy regarding the measures which were taken by the totalitarian state. Again, we can collect those no answers by the court. And for example, that was also raised the issue of if the Convention on Human Rights sets a standard indirectly for restitution, which would be followed by the states. The court said for this question also no, this is an issue which has to be determined by the national legislator. So in this context, we can say that each and every state had to decide if there is any restitution legislation, if the restitution is envisaged, then who are the persons entitled to restitution, and in which extent and under which procedure and under which condition the restitution took place. So this was the basic point of view of the court towards restitution, the issue of restitution. So, but we saw that if there are so many no answers, we have a lot of restitution cases. How this can happen? This can happen because the court actually said that it can check something. It can check something. It can check if the totally freely adopted restitution legislation and its application, in fact, it's in concordance with the Convention on Human Rights. And this set of cases, hundreds and hundreds of cases, gave rise to the case law of the European Court of Human Rights on restitution issues. And so I would like to point out the main findings of the European Court of Human Rights. The topic is really, really complex, and I can say, and this is my second conclusion, intermediary conclusion, that the restitution cases were the most complex legal issues which the European Court faced in its existence. This set of problem, not only legal but also moral, economical, political, and so on, set of problem was the highest complexity in the cases of the European Court of Human Rights. So I would like to point out as a conclusion 5 directions which the European Court of Human Rights followed in its legal practice. First, we have so many restitution cases which are not dealt under Article 1 of the Protocol 1. And they are dealt under Article 6 of the Convention on Fair Trial. So actually, if we take the statistical data, many fair trial cases are related to property. And a certain set of the cases is related also to the due process issue, failure to enforce judgments, and also administrative decisions, or it was also found that in some of the states there is a contradictory case law, so there is no unitary approach to same or very similar cases, which led to legal uncertainty. So this is another finding of the court related to due process, lack of legislative coherence. That was another finding. So in this direction, so we can find many restitution cases which were dealt under this due process scope of the convention. Of course, if a state freely, as I said, adopted restitution legislation after the ratification of the convention, or kept in force such a legislation after the ratification of the convention, this was protected under the Article 1 of the Protocol 1, in which sense, if the legal conditions set in that Restitution Act were met, and only in that case, because we saw that if a certain condition was not met, there was no actual right which have a protection. In that case, the court said that there is a legitimate expectation for restitution, so which can be protected. Third, very complex issue is, and due to the lack of time, I will skip it. Actually, just I will mention it. Is the question of the assets sold by the state to good faith third persons, even during the restitution procedure was ongoing, or even the Parliament was discussing at that moment of the sale restitution legislation and so on. This is a question which could not lead to a good result in the case law of the European Court of the Human Rights as well. So the court tried to do something, but the reality and the conflicting interest of different parties, the acquiring third person of good faith, and I put a question mark here if such person can be in reality in good faith or not, and has an interest, the state has an interest, the former owner or the heirs of the former owner had an interest. So the court could not find ideal solution to that issue. Fourth problem, compensation. And the court was also very careful about compensation because any decision could have macroeconomic effects, because the nationalization was not taking over one or two properties like in the West happened. It was a mass nationalization, so economic effects could be very high. And the court actually said that, okay, if there is a compensation which is reasonably related to the value, it's enough. So again, the national legislator can decide on compensation. That compensation is not required to be just. It is required to be reasonably related, not reasonable, reasonably related to the value of the asset, which means that practically a non-discrimination conclusion can be found here if compensation must be proportionate at the social level, not proportionate with the value of the nationalized good. And the last question, last issue is the length of the procedures, and which the court sanctioned. I can give Slovenian, Lithuanian, Bulgarian cases, but I will give again a Romanian one. The Roman Catholic Archdiocese against Romania. This is related to the very famous Batianeum Library, rare collection of manuscripts and books renowned at world level. For example, it has a so-called Codex Aureus, which dates back to the Carolingian times and so on. So it's very, very interesting collection. And the court in 2012 found that the procedure, which lasted 14 years, it was too long, and practically condemned Romania. This happened in 2012. In 2021, the state finally refused the restitution, and practically I saw the judgment, and for me it's not convincing at all. It's artificial reasoning. I can understand the Romanian state's intention to keep in state property this collection, but solve it in a legal way, changing the restitution legislation or something, not by artificially creating conditions of refusal of restitution claims. And as a final remark and the conclusion, just as the states have been only able to provide a partial solution to the problems raised by the past and the measures taken by the totalitarian regimes, also the court, having in mind the court's best intention, could not be a miraculous solution for these problems of the past. Thank you.